Hey, it's Barb here. I am here today with Serrambana from Surf City Lawyers, who is one of our very great business partners and preferred attorney for the Betts Realty Group, and she handles estate planning, probate, trust, wills, and business law. So thank you for being here today.
Thank you for having me.
We are here to talk about how to take title investing. It's one of our number one questions we get asked by buyers. Is when you open escrow, you get this giant escrow package with a ton of paperwork, and one of those is probably one of the most important documents is how you're going to take title to your property, otherwise known as vesting. Escrow is going to give you this form. It's going to have a ton of different options, and when you call escrow to ask them for help, they're going to tell you they legally can't give you advice. When you call me for help, I'm going to tell you that I legally cannot give you legal or tax advice, but when you call a wonderful professional like Anna, who is an attorney, she can give you that legal advice. So today we're here to help you through some of those questions you might have. So hopefully you can watch this video, make your own choice and your own decision, and then proceed with the transaction. So taking title is very important.
It is, absolutely. It has so many consequences.
So tell us a few of the pitfalls if you take it the wrong way.
So you could be responsible for a co-owner's liability. That's one of the pitfalls.
Okay.
You could have negative tax consequences if you take title incorrectly.
Mm-hmm.
That's another consequence.
Mm-hmm. And there's a lot of misnomers. You can also take it in a way that might not be the most beneficial way for your tax
Absolutely.
consequences.
Absolutely.
So let's talk about single clients.
Sure.
So single being, what fun fact I've learned is when you take title as a single person, if you've never been married before, you take it as an unmarried
Yes.
man or woman.
Absolutely.
But if you have been married before, you take it as a...
You can say divorced person. If you've been married and they've passed away, then you can take it as a widow. There's many different ways that you can take it.
So single is pretty much single, though. There's not a lot of...
There's no joint owner or anything else like that. It's pretty straightforward as long as you get the category right after the name.
Perfect. Now, the reason we're really here today is married clients.
Yes.
So married clients always ask me how to take title. It's a very confusing, can be confusing, and I actually always thought of it the wrong way for many years until you educated me. So let's talk about the two most common ways, joint tenancy and tenants in common.
Actually, there's the third one, which is community property.
See,
That's
the
the
third
third
one.
one.
Okay,
Yes.
so tell us
Yes.
about the three, and
Okay.
then tell us ultimately the one that's usually best for most married couples.
Okay, so the most, or the least common I'll start with,
Okay.
which is for married couples would be tenants in common.
Okay.
Most married couples don't take it as tenants in common, and the reason being that with tenants in common, you each own 50% of the property. You don't own it as a whole.
Okay.
So I'll just leave it at
So
that.
if someone passes away, you only own 50%
You
of
only
it.
own 50%, and their 50% can be deeded, willed, given away to anybody else that they so choose.
Okay.
Okay, so the second, actually the most common, which shouldn't be the most common, is joint tenancy.
Yeah.
And joint tenancy means that you own it as a whole.
Mm-hmm.
Basically, it's very similar to community property in that regard. You both own 100% of the property.
So if someone passes away,
Yes,
it goes completely to the other person.
that's correct.
Okay.
Yes. However, but if spouses take title as joint tenancy, then at the death of the first spouse, the surviving spouse will not receive a step up in basis,
Mm-hmm.
which basically means that if you bought the property at $100,000,
Mm-hmm.
the first spouse to die, it's valued at $500,000. You will not get a step up in basis for capital gains purposes to the $500,000.
Which is a big deal.
It's a big deal.
Yeah.
If you took title as community property, you do get the step up in basis.
So you recommend for married couples the community. Do you have to add the right of survivorship to it?
You should add the right of survivorship, yes. And I can explain that in a second. I just want to go back. You said, so I recommend for most married couples? Yes, most married couples. Not all the time, not 100%, but the majority of the time, yes, absolutely. And you should consult an attorney or a CPA to talk about that. But
Yeah.
You should add the words with right of survivorship, because even in community property state, you can still will your 1/2 community property interest
Okay.
to somebody else other than your spouse.
Interesting.
Yes.
Interesting. Now, the other confusing part is when clients come to me, domestic partners, maybe you're buying it with a family member, brothers and sisters buying together, sometimes business partners buying property together. What should they do about that?
Well, first, they should have a basic knowledge. They should consult an attorney. But when they're not married, then you take title either as tenants in common or as joint tenants. And I will always recommend that they take title as tenants in common in that case. For example, brother and sister buy property together or inherit property together. You don't want to be joint tenants because if, for example, brother gets in a car accident, gets a judgment against him because something happened in that car accident, then the entire
Gotcha.
property can
Yep.
be liened, and then sister is out of her inheritance completely.
Ooh.
With tenants in common, they can only go after brother's half of the property.
Gotcha. So you guys are hearing why it's so important to have an attorney look at each individual situation. Married couples can be sometimes cut and dry, but anyone else, domestic partners, brother, sister, family member, you're buying it with your friend, call an attorney that's educated. Anna has created an amazing way to take title vesting information sheet, and the link is definitely included in this video, and we highly recommend you take a look at this, read through it. But ultimately, if you have questions, Anna is a great resource. She's happy to answer questions for you before you sign off on how you're going to take title, because it is such an important part of the transaction, and if you don't do it the right way, it's going to be too late.
Absolutely.
So now, tell us a little bit about the importance of a trust after buying a home and the bullet points of what it does to help you.
Okay. So in California, if you have a gross estate of $150,000 or more, it has to go through probate. And probate is a court process, takes over a year. It costs, in California, with an average home of $500,000, it's costing about $13,000 in fees, plus expenses on top of that.
Wow.
And then if you have, and that's fees for the administrator. If you have an attorney, it costs double.
Wow.
And your loved ones are not going to get their money for over a year. So
Wow.
a way to avoid that and save on hassle and expense for your loved ones is to have a trust. Once you put the home in a trust, it doesn't have to go through probate anymore. So you spend a little up front, but you save a lot in the end.
Mm-hmm. And what other protections does it provide you
Well,
while you're alive?
While you're alive, if you become incapacitated, then somebody can immediately take over and handle your estate. You don't have to go and get a conservatorship through the court system, which is, again, going to cost thousands and thousands of dollars. Through the trust, you can also create some spendthrift provisions in case you have a child who has creditor issues or special needs. You can save, yes, you can save that child from losing their government benefits.
Interesting. And so for that, they would get a hold of you and you can help them from A to Z, set the whole thing up.
Absolutely.
Absolutely. All right. Well, thank you so much for being here today. We hope this was informational and educational for you. And again, I can't emphasize enough, if you have any specific questions with regards to taking title, vesting, ownership to a property, estates, trusts, wills, or she is a great business attorney as well, I highly encourage you to reach out to her, and her information will be included below this video.